I want to talk to you about how you can get stuff out of your name for Medicaid eligibility purposes, but retain many of the tax advantages that exist when you leave things to your children. So I'm talking about what's called the step up in basis. And you really lose all of these tax advantages when you just take what you have and you put it in your kids' names. If it's something that has grown in value, you put it in your kids' names, they sell it, they have to pay a lot of capital gains tax. However, if you take that same asset that has appreciated, put it into what's called a very particular type of grantor trust, then when you pass away, your children get this step up in basis, so when they sell the asset, there won't be all of this capital gains tax to pay. So keep in mind there's just some negative tax reasons to put stuff into your kids' names, those negative tax things being your children will have what's called a carryover basis in those assets. Whereas if you put them into a special type of grantor trust to get those assets out of your name for Medicaid purposes, but when you pass away, your children will still benefit from that step up in basis, all that appreciation goes untaxed. So just be aware that there are some ways that you can set things up to get your assets out of your name for Medicaid purposes, but still retain that step up in basis so that when you pass away and the children get the assets, if they sell those assets, there won't be capital gains tax to pay. I'm Paul Rabelais. If you have questions about that, you can contact our office, 866-491-3884. You can even send me an email if you're interested in retaining our services to help you with this, paul@rabelaslaw.com. Have a great day. Go Tigers.